Welcome to Education in Focus. I'm your host, Eliana Kernodle. A federal court in Kentucky last week ruled that the Biden administration's rulemaking expanding Title IX to include gender identity is, quote-unquote, unlawful. Joining me to dig into this is Chalkboard News editor Brennan Clary. Brennan, many cases have been brought against the Title IX rule change. How does this one fit in?
Yeah, so this was one brought by the states of Kentucky, Indiana, Tennessee, West Virginia, and then some other private organizations and individuals. So that is one of many. I'm trying to remember exactly. I don't remember off the top of my head exactly how many, but there was a number of different legal challenges across the U.S. And even before this ruling, there was sort of a piecemeal implementation of the expanded regulation. So I think 26 states and thousands of schools were exempt from the guidelines because of this litigation, and there were holds from the court saying you can't implement this yet while we're talking about it. So this is one of many, but this is a definitive ruling unless the Department of Education were to appeal it, and then it would go to an appellate court, and then all the way up probably to the Supreme Court. Unfortunately, the Biden administration is out of time, so we have an inauguration coming up, and I don't think that they can do that. I asked them if there was anything that they're going to plan on doing, and they said they didn't get back to me. And again, we're down to the wire in terms of what the Biden administration has left. So this is a round sort of condemnation of how the Biden administration tried to implement these regulations, because the court said that it overstepped its authority constitutionally and that it would not be allowed to stand. And so we're going back to 2020. So when Trump left office, essentially, we're going back 4 years in terms of the regulatory outlook. And so that is that's where we are in terms of the litigation.
And let's get into the reasoning behind this ruling. What did the court rule?
Yeah, so one of the big things is that it overstepped the Department of Education overstepped its congressionally given boundaries. So specifically from the court documents, Judge Danny Reeves wrote that Congress gave the department authority to issue rules, regulations, and orders to effectuate Title IX's prohibition on sex discrimination consistent with the objectives of the statute. However, the department exceeded that authority in issuing the final rule, and the text of Title IX shows why. And then he gets into it a little bit more that there's nothing in the text or statutory design of Title IX to suggest that discrimination, quote, on the basis of sex means anything other than it has since Title IX's inception. So essentially, they're trying to redefine what the law is saying, and that, as this court and others have explained, expanding the meaning of, quote, on the basis of sex to include, quote, gender identity turned Title IX on its head. So what the judge said is that it actually flips the understanding of the law around, and that while Title IX sought to level the playing field between men and women, it is rife with exceptions that allow males and females to be separated based on the enduring physical differences between the sexes. So there are men and women's sports for a reason, right? That they can't compete. They shouldn't have to compete on the same kinds of teams, or have everything the same. Like there are these opportunities that exist while recognizing that there are differences between the sexes. And he said that the final rule's approach to locker rooms doesn't make sense. So I mean, again, these are kind of like it's a round condemnation of a lot of these different regulatory changes that the Biden administration was trying to make. And he called it arbitrary, that the department has offered no rational explanation for the stark inconsistencies that will result if the final rule is allowed to go forward. Another thing, too, the final rule is vague and overbroad. As the court explained previously, several other terms used in this regulation are so vague that recipients of Title IX funds have no way of predicting what conduct will violate the law. Like what would it mean to break the new rules? So also the spending clause of the Constitution, that it violates that. It's also arbitrary and capricious, Reeves wrote. Also, he said the reliance on a previous Supreme Court decision called Bostock. He said that was that case was clearly limited to the context of Title VII and did not purport to address what we're talking about in the rule here: bathrooms, locker rooms, or anything else of the kind. So essentially, in conclusion, he said the final rule and corresponding regulations are invalid and must be set aside. and that instead of that, we would simply return to the status quo that existed for more than 50 years prior to its effective date. So that is kind of what he said in the court documents are in saying we're going to strike this down.
And what impact does this ruling have on the various other cases that were brought against this rule change? Yeah,
I think those are going to continue to be litigated until they have a conclusion. So there's other cases, for example, the Southeastern Legal Foundation. There's different. They're litigating one, I think, that's based in Kansas, and so there's these different other ones. And so I think that would. Those are going to continue and going to have separate decisions from federal judges. But I think that anything, it looks like they would probably all maybe track this way because of how many of them have provided injunctions or like these opportunities to hold the enforcement in a lot of these cases. Just and for the same reasons about the constitutionality questions and different kinds of, the same arguments that were brought up in those cases. So I think that those do have the critics of the regulation and the rewrite. They're looking forward to having, those litigation victories in the coming weeks, maybe months, even too. I also think with the Biden administration becoming the Trump administration, that appeal is very, very unlikely. So I think that we're going to continue to see, different courts weighing in on this. But in terms of the effect, it's hard to say what would happen. Even if one said, no, we're going to start with the Biden administration, that would be a very interesting situation, I think.
And how have people reacted to this decision?
Yeah, the Biden administration, Department of Education, they didn't respond to my request for comment about whether they're going to try to appeal or anything like that. I mean, it would be an 11th hour sort of initiative here if they were going to do that. But a lot of critics of the rewrite were just very, very excited. So that was a pretty immediate response of, hey, this is a huge win for parents, that the Biden administration did not get that victory that they wanted. The Foundation for Individual Rights and Expression, for example, said that this would have like bigger impacts on school campuses, college campuses. So that was one aspect. But I think a lot of in the K-12, Betsy DeVos, for example, former education secretary under President Donald Trump, said that she called it radical, unfair, illegal, and absurd, the rewrite. And she said it's gone. So just a lot of celebration from people who are very opposed to it all the way through. And kind of not a lot of conversation from the Secretary Cardona, for example. I don't think he's said anything about it on Twitter or been very public about it. I think that that's usually the state of things, I think, in Washington when you have like a defeat like that.
Well, Brendan, thank you for your insights on this story. Listeners can keep up with this story and more at chalkboardnews.com.